Good morning, ladies and gentlemen. Welcome to another episode of PLA with myself, Nick and Bruno. We've got two questions today, once again, which we'll be separating, one for Bruno and one for Nick, and then they will obviously chip in both of them whenever the need arises. First question is for Bruno, and of course, Nick, you're free to also assist. This is one that's got to do with, we received a question from an estate agent who focuses a lot on leasing, right? And she wants to know an answer regarding leasing mandates, right, and securing commission, right? Basically, what had happened is that there was an early termination of the leasing mandate by the landlord, and now the estate agent wants to know what can she do in terms of claiming commission for the terminated mandate. So the landlord has terminated the mandate, and so how do mandates work with regards to claiming commission around that table, no?
Cool, awesome. So it's actually quite an easy answer. Unfortunately, it's not a solution that's implemented very often, which is unfortunate. And so the reality is that mandates should be in writing. There is this misconception that a mandate need not be in writing, and I've even heard from some estate agents that they prefer it not to be in writing. It makes very little sense to me because a mandate is templated. Just prepare it once off, make sure that it's done properly, and you can use the same template across the board. I've seen some great mandates. I've done some great mandates. You can do it as a little tick box exercise where a person selects their particular option, and it's very, very easily rolled out. So that's just the first thing that I want to mention is mandates should be in writing. It's not that they have to, it's that they should. Why? It's exactly for reasons like this. The industry has certain practices that it relies on. And the reason why people feel that mandates are necessary is because, as with sales agents, for example, there's certain commissions that a person expects receiving if they sell a property. So not having a mandate with a specific commission, they tend to fall back on the notion of, yeah, but the industry norm is X%, so that's what I should be getting. The problem is that as businesses, things like industry norms start creating difficulties because businesses identify themselves by being different. And if you're not, if everyone does the same thing, you're never going to actually be able to move your business forward. So as estate agents, there's a lot of practices that, whether they're common or uncommon, is actually uncertain because, as we said at the moment, one agent charges a procurement fee plus an administration fee or a management fee per month, whereas other agents don't charge a procurement fee at all. They don't even speak about it or mention it. Some landlords have no idea that a procurement fee could actually be charged because it's just not mentioned. They get someone, they put them on the property, and they start charging a management fee. Other agencies, the smarter agencies, or at least the agencies that have made the effort of preparing their mandates properly, specifically mention there is a procurement fee, there is a management fee. If you give me the management, I won't charge you a procurement fee. Now, so trying to bring this back to the question, is a landlord allowed to terminate a leasing mandate? Yes, depending on the terms of the contract. If the contract is month to month, where they hire you out, you rent out the property, you find the tenant, put the tenant there, send them invoices, and he decides, cool, well, job is done, I want to self-manage, he's more than entitled to, because your mandate doesn't say otherwise. To now go back and say, hold on, wait, but it's early termination, I should have charged you a procurement fee. It's too late for that. So my suggestion would be, have a mandate that specifically speaks about a procurement fee, specifically speaks about your management fee, and specifically speaks about the length of time that you're expected to manage the property. If you enter into this contract and say it's a fixed term contract for 12 months, and I will not charge you a procurement fee provided that I manage the contract for 12 months, then at least you've got something fixed. So now the only challenge would be, in terms of the CPA, someone that's stuck in a fixed term contract like a landlord can terminate it early, but then you're entitled to charge a cancellation penalty, which can very easily be for example, very easily, the procurement fee becomes due and payable if the contract is terminated before the 12-month period or something along those lines. So you can construct your mandate to tie in a landlord, be it by offering him a lesser commission if he takes you on for a longer period of time, but just make sure that you've got a mandate to cover it.
Well, 100%. They're just highlighting, of course, the importance of having agreements in writing and obviously mentioning all the necessary clauses in terms of your fees and your time and cancellation or breach clauses.
Sure.
So yeah, that definitely covers it for that question. Nice, short, and straight to the